Hey guys, Todd Vanderwide back again. Late yesterday, the Fourth Circuit Court of Appeals decided to en banc the Bianchi challenge to Maryland's semi-auto ban after oral arguments, but before a final decision was rendered by the three-judge panel. If you're as pissed off as I am, let's talk about our options after this. All right, guys. Todd Vandermide, former NRA contract lobbyist, Illinois gun law guru. As you may notice, I'm back in the home studio. I came home. It's the first time I've gotten to sleep in my own house in almost 3 weeks since my wife's stroke. We'll have updates on that, but she is doing better. I'm encouraged. But I got home last night and I was so pissed off. I could not see straight. I was just enraged by the games that are being played, especially now in the Fourth Circuit. And I wanted to do a video then, but I was too mad. And I thought I talked to some people, gamed some stuff out, and I think that we now have to change up some of our tactics. Cooper and Kirk was handling this lawsuit, if I remember correctly, and I have worked with the people at Cooper and Kirk, Pete Patterson, Dave Thompson, on NRA lawsuits that we had. Worked with them on the Shepard case. They were involved in the Cook County ammo tax. Chuck Michelle, I've got a good, close personal friendship with Chuck over at Michelle and Associates and all the work he's done for the California State Rifle and Pistol Association. So I know some of the players in some of these cases. I've gotten to know Erin Murphy a bit from Clement and Murphy for her work in the Illinois gun ban case. And we have reputable, honest lawyers. And I think that the problem we are facing is it is becoming harder and harder as a person who believes in the Constitution to sit there and with a straight face and not see that there is corruption running through the federal judicial system along an ideological line, and that in their mind the end the goals justifies any means by necessary to seek or obtain the outcome that they want. All this time we have been acting as gentlemen. We have been acting under the guise of the Constitution. We have been acting under the principles of the four boxes, knowing that, we had salvation and hope within the third box of the judiciary. And what the Fourth Circuit did yesterday was just to rip the scab off and lay bare the absolute judicial corruption that is prevalent in many of our appellate court circuits. And I'm going to start with the Ninth. And if you remember, during Duncan, it was headed back to the three-judge panel, and then the three-judge panel all of a sudden had it snatched from their hands by the entire Ninth Circuit in an en banc decision. They said, hey, oh no, we're going to claim this case as a comeback case, and we are going to just take it to the en banc, because the habit was you draw a good three-judge panel in the Ninth Circuit, and then then we would win at the three-judge panel, and then the en banc would reverse. Duncan was pending at the Supreme Court when New York v. Bruin was decided and remanded. It was GVR saying, try again, see New York. Well, then after New York, we had the Second Circuit, where we had a bunch of wins at the trial court level, and then the uh, the Second Circuit Court of Appeals was issuing stays of injunctions without comment. They were dragging their feet on stuff, and they got kind of slapped down by the Supreme Court. They were given a rap on the wrist, and they were told, hey, because the people in the Second Circuit, the plaintiffs went up and said, hey, this isn't right. And Justice Thomas and I think Justice Alito sent them a little note. And now we have the Fourth Circuit. So what do we have? So Bianchi was argued 13 months ago at oral arguments. It was GVR'd. It was one of those cases that were sitting at the Supreme Court. It was granted, vacated, remanded, sent back to the three-judge panel. It went to the three-judge panel, and it sounded like we had a solid 2-1 decision coming down against them. Now, what I want to know is why did it take them 13 months to do this? Look at our own case here in the Seventh Circuit. We were in front of the court May, and we had a decision in November. So 5 months. Not light speed, but a fair pace, if anything, for what we had. So here you have 13 months. Everybody is on bated breath, expecting we're going to get a good 3-judge ruling. That would set up a circuit split, make the odds of the Supreme Court taking a case more. We knew that there was a chance it would go en banc and be reversed, and here we go. The internal workings of the Fourth Circuit. It would be nice if we had a judge step up like Van Dyke did out in the Ninth Circuit and just start laying it out in the open. And so that's where I'm thinking we need to change our tactics. We have been fighting, we've been coloring inside the lines. We have been fighting by the Marquis of Queensberry rules.
Gentlemen, if you please, this is a private fight. The Marquis of Queensberry rules will be observed on all occasions.
Now, the Marquis of Queensberry rules, mind you now, Squire.
Okay with me, Michelin. Thanks.
Non-belligerents will kindly remain neutral. Now, shake hands and come out fighting. I thank you.
Do you hear that, everybody? The Marquis of Queensberry rules.
No, the Marquis of Queensberry rules.
Marquis of Queensberry rules.
We have been being honorable plaintiffs and honorable participants within the judicial structure that we have, trying to apply the law faithfully, and the other side is anything but that. They're despicable, they're dishonest, they are, I think Arlie Ermy could probably describe it better.
You are pukes. You are the lowest form of life on earth. You are not even human fucking beings. You are nothing but unorganized, grabastic pieces of amphibian shit.
So, with that, I think we need to change up our tactics. I think there's a couple of things that we can do. First, let's start at the grassroots level. I believe that every gun rights organization in this country should start either an email, letter writing. I don't think petitions do all that well, but I think well-written letters from organizations that get sent and submit them to Jim Jordan. And the text and context of these are that there is a corruption running rampant through the federal appellate court judiciary system when it comes to the Second Amendment and the litigation surrounding it. And we have the Second, the Fourth, and the Ninth, and the Seventh to point to. And I think that we need to start asking Mr. Jordan, because the House Judiciary would be one of the oversight committees that would potentially open an impeachment investigation into some of these judges. I think it would be very interesting for Mr. Jordan to open up a hearing about how the Second Amendment is being treated differently in litigation in these various courts. And if you go back and read the opinion from Judge Van Dyke. And I think it would be very interesting to have Justice Van Dyke there under oath in front of the House Judiciary Committee to explain and answer questions about things that he elicited and enumerated in his opinion that came down and a dissent from the En Banc panel snatching up the Duncan case. I think it would be very interesting to have a couple of the judges from the Fourth Circuit be asked to come in and explain why it was taking 13 months to get an opinion that seems so cut and dried from the oral arguments, and to sit there and ask them what's going on behind the scenes. I mean, if the CIA could keep secrets as well as some of the federal judiciary, we wouldn't have a problem in this country as far as our intelligence apparatus goes. But the only leak that you've really seen is out of the Dobbs decision. And so in my, lifetime on this third rock from the sun, it's amazing. But I think that we need to seriously start asking questions because Congress has an oversight role. Congress has the ability to look into things. And if there were to be an impeachment of a federal judge, that would start in the House of Representatives. So what better than to ask Jim Jordan, give a rat's ass about Hunter Biden right now, but to sit there and start making inquiries of the federal judiciary and ask for a hearing for them to look into the improprieties that are taking place around this litigation. That's number one. I think that if we all start banging on Jim Jordan, I think if he comes on a podcast somewhere, people start putting the question to him. I watched Guns and Gadgets do something with Jim Jordan in a very short interview. Good move, great, kind of gets the point across, but I think we need to up the ante. They were talking about expanding the Supreme Court. I think we need to start having investigations about the possible improprieties that could be impeachable offenses by federal appellate judges. They want to up the ante? I say let's up the ante. The other thing that I think should be considered on people on our side, and I think that since Bianchi is a FPC SAF case, I think, and I'm not an attorney, but I think they would have a strong case with at least the gun-owning public and the 2A community that remember when in the New York case, they went up to the Supreme Court and said, hey, what gives? And the Supreme Court sent back down and kind of slapped the Second Circuit around a little bit, so you can't keep doing this. I think that a petition to the Supreme Court by the plaintiffs in Bianchi for them to review before a final judgment is rendered and saying we can't get a fair shake and point to the corruption within the Ninth Circuit, point out the irregularities of this case. They should be so cut and dried. Remind them of what the Second Circuit was doing until they intervened. And just maybe we can get something out of Justice Thomas, Justice Alito, Justice Barrett, Justice Gorsuch, or Kavanaugh. And if nothing else, lay it bare and put it in front of their face to where they can't ignore it. It is now a cert petition in front of the Supreme Court, and you are asking them to take it based on the improprieties, the irregularities, and the open appearance of a conflict of interest or a predetermined outcome one way or the other. And just lay bare what I'm calling the absolute corruption within the liberal appellate districts. And I mean, I don't know, since the guys down in the Fifth Circuit seem to be getting it so right, can we, is it time to have some tiny town in Texas pass a gun ban so we can have it litigated through the Fifth Circuit and not have all these bullshit games in the seventh, in the ninth, in the second, whatever? Can we? I mean, all right, guys, maybe it's time to just take one for the team and let it go. You know, just so we have because you're never going to see a gun ban come out of the Fifth. You're never going to see a gun ban come out of some of these other circuits that are good for us. And it's, you know, and starting a new case now, oh my God. So we are knocking up on 15 minutes here. I'm trying to keep my videos ever so slightly, you know, shorter under that 15-minute line. But guys, thank you for all the thoughts and the well wishes and concerns for my family and my wife. It doesn't go unnoticed. Another shout out to the medical teams. I mean, we have a stroke team, we have an ICU team, we have a neurological surgery team, we have an internal surgery team. She's had 6 different operations or procedures in the last 3 weeks and everything. So a shout out to Rush Medical for everything. And now we're going to have a physical therapy team on top of that. So with all that, really to them, to Gun Barrel Coffee for providing some of the caffeine for the teams down there, and for me to keep doing it. I really want to say thank you to those guys all over again. Sal and everybody, salute. Lastly, please like, copy, paste this link around, subscribe, share this on all your social media pages. Do all that. Help. Let's keep spreading the word. We'll have some more conversations about this. But as always, frag out.